going to be a plea?
Your Honor, I think the district attorney and I have agreed that if Mr. Mary enters pleas to an amended count 2 for possession of THC and count 3 possession of drug paraphernalia, we'd be recommending court costs on both. If the court is comfortable taking those pleas without a plea questionnaire, I think we're ready to go.
Okay, let me just see. He has 250 posted. So it would be THC and what?
Paraphernalia.
THC and paraphernalia. Did he do the AODA? I think, wasn't that one of the conditions?
He did.
He's in King, please. All right. Mr. Mary, can you hear me?
Yes, ma'am.
I am going to ask you to start your video, please, if you can.
Okay.
There we go. We will go on the record in the matter 24 CF 113, State of Wisconsin versus Michael Mary. The state appears through Assistant District Attorney Holly Rockow in person. We have Gabriel Pollock, Defense Counsel, in person. Mr. Mary appears by video conferencing. We're set today in this matter for a status conference. However, before the court called the case, the parties informed the court that they have reached an agreement. And if the court is okay with it, we can go ahead and move forward with the plea on the record today, if Mr. Mary wishes to do so and wishes to waive his personal appearance. Mr. Mary, are you comfortable proceeding by video conferencing here today?
Yes, ma'am.
Okay,
yes,
and do you understand you have the right to be here in person with your attorney and in front of the court?
Yes, ma'am. Yes, ma'am.
Okay, and you're okay with yourself appearing by video conferencing?
Yes, ma'am.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know so I can have him do what he did prior and go into Zoom, and I can send you into a confidential breakout session, okay?
Okay. Yes, ma'am.
So the agreement is that you would plead guilty to an amended count of possession of THC as a misdemeanor and to a count of possession of drug paraphernalia as a misdemeanor. And there would be a recommendation to the court of court costs. And that's accurate and true for the recitation of the agreement, Mr. Pollock?
Yes, Your Honor.
Formal motion to amend count 2. So made. Granted. Mr. Mary, how old are you?
I'm 54.
Can you read, write, and do you understand the English language?
Yes, ma'am.
Any drugs, alcohol, or other medications in the last 24 hours?
No, ma'am.
Have you been deemed mentally incompetent or suffer from a mental disability?
No, ma'am.
Has your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt and maximum possible penalties?
Yes, ma'am.
Now, do you understand that you would have the right to have certain constitutional rights, and that would include the right to a trial, the right to have your attorney cross-examine the state's witnesses and call witnesses to testify for you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision to find unanimous decision as to a guilty verdict or find you not guilty. You would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you would be giving up here today?
Yes, ma'am.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
Do you understand that with regards to these cases, the state would have to prove that on or around May 3rd, 2024, you possessed a substance, the substance was a controlled substance, here, THC, and that you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes, ma'am.
You understand the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
Yes, ma'am.
You also understand that as to possession of drug paraphernalia, the state would have to prove the same date, the same time, the same place, that you knowingly possessed with the primary intent to use a pipe to inhale a controlled substance. Do you understand
ma'am.
what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $500 or imprisonment of up to 30 days or both?
Yes, ma'am.
And do you understand that the recommendation here is for court costs only, but you understand I don't have to follow that?
Yes, ma'am.
Said differently, I could sentence you all the way up to the maximum possible penalty if I thought it was warranted, and I could do so here today. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Now, did you go over the criminal complaint with your attorney at some time? And that would be that document, the original charging document that basically says what happened that day and why you were charged with these crimes?
Yes, ma'am.
For the most
Right.
part, are those facts accurate?
Yes, ma'am.
Did you in fact possess THC?
Yes.
Did you in fact possess a pipe to inhale a controlled substance?
Yes, ma'am.
Mr. Pollack, may the court use the probable cause section of the criminal complaint to find a factual basis?
You may, Your Honor, as well as the statements made by Mr. Mary just now.
Thank you. Has anyone made any threats or promises to you, Mr. Mary, for you to plead guilty to this charge?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today?
Yes, ma'am.
And intelligently and voluntarily. Are you satisfied with your attorney's services?
Yes, ma'am.
Has he done a good job for you? Do
Yes, ma'am.
you have any questions for the court or for your attorney before I proceed?
No, I don't.
Then as to amended count 2, possession of THC as a misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt, or actually as to count 3, possession of drug paraphernalia, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of amended count 2 and count 3. Count 1 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Ms. Rockow.
Your Honor, I'd ask you to adopt the joint recommendation for court costs. Mr. Mary did complete an alcohol and other drug assessment. There were no recommended follow-up treatment, anything like that. So I think that cost is appropriate. Also, Mr. Mary had a very small quantity of THC in his possession. It looks like the officer weighted at 0.54 grams. So I think this is in the public interest. Thank you.
All right, thank you. Mr. Pollack.
Your Honor, I concur with Ms. Rocco. I also believe that Mr. Mary was honest with the officer when he asked if that was the THC was in fact his. I think he admitted that fairly readily. He was arrested that night for what it's worth, and that was May 3rd of 2024, and the $250 cash bond was posted on May 6th. So it appears he did have approximately 4 days of credit. Although the recommendation is for court costs, it's worth noting there was some punishment and some time that he spent in custody. I don't believe 3, 4, 5, 6, 4 days, Your Honor. He has no additional open cases or anything that I'm aware of. The primary issue with this was simply getting funding from the Mille Lacs Band so that he could have the assessment done. Once that actually occurred, as Ms. Rocco stated, they did not find that he was high risk or high need such that he needed any sort of detox or follow-up or anything of that nature. This is a situation where he's engaged with his tribe in Minnesota, appears to be doing very well. I don't think that there'd be any benefit to placing him on probation at this point and returning him to Burnett County. So I think this is an appropriate resolution, and I urge the court to adopt it.
Thank you. Mr. Mary, do you care to make any statement here today? You don't have to, but it is your only time to tell me anything.
No, ma'am, I'm fine with everything.
All right, thank you. All in all, in looking at the facts of this case and knowing what you did, going and doing the AODA assessment and that follow through and having some connection with mental health specialists as it relates to any alcohol and or drugs. I don't find this to be an extremely serious case. You do live in Minnesota, in Hinckley, Minnesota. In Hinckley, Minnesota, THC is legal. In Wisconsin, it is not legal. Therefore, you can do what you will in the state of Minnesota as it relates to marijuana and THC. You cannot in the state of Wisconsin. So I believe that the crimes that you pled to and having criminal charges is punishment enough, along with the fines and fees and court costs that you will receive as it relates to this and to these matters. You originally had $250 posted. That was ordered forfeited, I believe around May 22nd, 2024 for a failure to appear. What I'm going to do is I have not yet received an order from the state to completely forfeit that, to have that go to the county general fund. So I'm going to set that forfeiture aside. So I have a total of $750. I'm going to assess $443 in court costs and fees for count 2. I'm going to assess $307 for count 3, and I will waive the remaining court costs and fees for count 3. That means you're going to be paid off in full for your fines, fees, and court costs. I don't think that you should have any other penalty associated with these crimes, because you are being accountable and you're being responsible and you are pleading guilty to crimes, and they are now on your record. You have 20 days to appeal. Should you fail to appeal in 20 days, you do lose that right. I do have to order that you provide your DNA to the Sheriff's Department, the Burnett County Sheriff's Department. I'm going to give you 60 days to do so. All you need to do is call the Burnett County Sheriff's Department and see if they need your DNA. If they do, they'll let you know, and you can arrange a date and time to come up here to provide a sample to them. It's just a little swab in your cheek, and it would be something that you can apply in a written letter to the Department of Justice to have it removed from the CODIS system, if that's something that you wish to have done. But you still need to provide that DNA sample to the Sheriff's Department per statute. Again, 20 days to appeal. Talk to your attorney about that. I am also going to order 4 days of jail for count 2 and for count 3 to run concurrent. You have 4 days of jail credit. You might as well get the credit for the time that you served in jail. So I'm going to give you that credit as well. I think that covers everything. Ms. Rockow, anything I'm missing?
I don't believe so.
Mr. Pollock?
Not for me, Your Honor. Thank you.
All right, thank you. Thank you, Mr. Mary. We are adjourned.
Thank you. Yep, thank you.